Imagine you have immunity for any bad actions you take. You've probably heard of diplomatic immunity, where officials of other countries are shielded from prosecution. Well, then there's sovereign immunity, where the head of government cannot be charged. In America, though, our legal system has come up with the idea of qualified immunity. While the idea of qualified immunity may make sense in some situations, and like so many other things, it has been badly abused by those in government. The state of New York is considering legislation that may put the brakes on some of the abuses of qualified immunity. Now, would this make things better or worse? We'll discuss that next on the Constitution Study.
Love your neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engley here with the Constitution Study, where we read instead of the Constitution. We teach the rising generation to be free. I am so glad you could join me today. 2023 is getting off to an interesting start. There's a lot of things going on around here. If you want to find out more, well, head to the website and sign up for one of the mailing lists. I've got the newsletter, the insider, even have my posts and videos delivered directly to your email. I'm going to talk a bit more about that at the end of the episode, but now let's dig into this idea of qualified immunity. Think of immunity as a get-out-of-jail-free card. Now, under the right conditions, you are not held accountable for your actions. In monarchies, the sovereign has their own form of immunity. Sovereign immunity, or crown immunity, is a legal doctrine whereby a sovereign or state cannot commit a legal wrong and is immune from civil suit or criminal prosecution. We've all seen examples of diplomatic immunity in the movies or television. It's usually a bad guy using his or her diplomatic position to get away with their criminal activity. And we cheer when they get their comeuppance. Diplomatic immunity is a form of legal immunity that ensures diplomats are given safe passage and are considered not susceptible to lawsuit or prosecution under the host country's laws, although they may still be expelled. In the United States, we don't have a king, so there's no sovereign immunity. We do extend diplomatic immunity where appropriate. Our courts, however, have created a qualified version of immunity. Qualified immunity is not like diplomatic immunity. It's more like sovereign immunity light. In the United States, qualified immunity is a legal principle that grants government officials performing discretionary functions immunity from civil suits unless the plaintiff shows that the official violated clearly established statutory or constitutional rights of which a reasonable person would have known. Now, the idea behind qualified immunity has some merit. A government official cannot be sued unless the petitioner shows that there was clearly established rights that were violated. It's those words, clearly established, that have led to so many problems. What is a clearly established right? You would think the plain language of the Constitution and laws of the United States would clearly establish the protection of those rights, but judges don't always agree. Just look at how often judges, including justices of the Supreme Court, claim that a right clearly established in the Constitution can be violated if there's a compelling state interest. In U.S. constitutional law, when a court finds that a law infringes a fundamental constitutional right, it may apply the strict scrutiny standard to nevertheless hold the law or policy constitutionally valid if the government can demonstrate in court that the law or regulation is necessary to achieve a compelling state interest. I find this standard very interesting. You see, not only does the Constitution clearly state that certain rights will not be infringed or abridged, but it's actually a violation of federal law for government actors to do so. They can even be sued for depriving someone of a right protected by the Constitution or laws of the United States under 42 U.S.C. 1983. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit, inequity, or other proper proceedings for redress. Why do the courts still claim that a right has to be clearly established before someone can be sued? simply because that someone was working for a government when they violated your rights. Now, with this in mind, let's look at the legislation submitted to the New York State Senate. This legislation would amend New York State's civil rights laws with the following language. Civil action for deprivation of rights. A person or public entity acting under the color of law that subjects or causes to be subjected any other person to the deprivation of any rights, privileges, or immunities secured by the federal or state constitution or laws is liable to the injured party for legal or equitable relief or any other appropriate relief. Similar to 42 U.S.C. 1983, this law would ensure that someone who deprives another of a right protected by the Constitution or laws of the United States or the state of New York can be sued for damages. That, however, is not where the question of qualified immunity comes in. That comes in Section 3. Statutory immunities and statutory limitations on liability, damages, or attorney's fees do not apply to claims brought pursuant to this section. Now, I have plenty of complaints about the Empire State, but if they pass this legislation into law with this language, I will give them full credit for doing something right. There is no reason someone who deprives others of a right or privilege should be held not just criminally, but civilly liable simply because they work for government. There needs to be consequences for such bad behavior. From the New York State legislation, it shall not be a defense or immunity to any action brought for the deprivation of any rights, privileges, or immunities secured by the federal or state constitution and laws that such defendant was acting in good faith, or that the defendant believed, reasonably or otherwise, that their conduct was lawful at the time such conduct was committed. Have you ever heard the saying, ignorance of the law is no excuse? What's good for the citizen should be good for the government actor. Just because someone believed what they were doing was lawful isn't a defense for anyone else, so why should it be one for a government actor? Doesn't that effectively put them above the law? Continuing, nor shall it be a defense or immunity that the rights, privileges, or immunities secured by the federal or state constitution or laws were not clearly established at the time of their deprivation by the defendant, or that the state of the law was otherwise such that the defendant could not reasonably have been expected to know whether the conduct was lawful. And here we deal with that clearly established language. I remember reading about a case where a law enforcement officer was acquitted for shooting a family dog because no court had ever said it was a clearly established violation of the owner's rights to do so. If New York State enacts this legislation, then that would no longer be a defense within the state. The immunity language in New York SB 182 is pretty good. The real question is, why is it not standard practice? Why isn't the plain language of the Constitution and laws of the United States not considered clearly established? Why does the court need to put their blessing on a law for it to be so? I have my ideas. One of the ways to control something is to shroud it in mystery and special knowledge. If the law means exactly what it says it means, then why would we need all these lawyers? By wrapping up the whole legal process in jargon and commentary, it's easier to keep everyday people out of the loop. That, though, cannot be the only reason. Let's face it, power corrupts. If you have the power to reinterpret the laws to your own advantage, it's difficult not to take advantage of such power. And since the judicial branches are just as much a part of government as the legislative and executive, why wouldn't they feel the need to protect their fellow government actors? And it may not even be a malicious intent, but when drilled into our attorneys in law school and by their judicial opinions, they are taught to worship. If you live in the state of New York, I would keep an eye on SB 182. It may become a great tool to protect your rights from the bad actions of government employees. For the rest of us, I think we should consider approaching our state and federal representatives about including similar language in the laws of our states and of the United States. It would put us one step closer to the land of the free we so often sing about. Imagine that. Imagine living in a country where simply getting a government paycheck isn't a get-out-of-jail-free card, where we hold our government actors accountable for their bad actions, and the actual language of the Constitution and laws of the United States are clearly establishing the rights that are protected. I love the idea. I loved it so much, I brought this New York State legislation to you, hoping that other states would adopt it. Maybe even the federal government would adopt it. Who knows? It's worth a try. But by understanding the concept of qualified immunity and the infringements on our rights that it brings to us, we'll be better prepared to defend ourselves from it. It starts with knowing what your rights are and understanding that it is the Constitution and laws that clearly establish, not what some judge says. We need to break this idea that just because a judge says something means it's true. The other thing we should be doing is working with our state and federal representatives to get such language included into the law. How about we short circuit the courts by actually clearly establishing in the law that you cannot use some nebulous idea about the courts as an excuse for your bad actions. I'm not out to get government actors, but if they're acting badly, I want to stop it. And the easiest way to do it is start holding them accountable. It's really the basis of most of our laws, isn't it? You hold those acting criminally accountable in the idea that they won't do it again or others will avoid doing it for the same punishment. Now, before I go, I do want to remind you, please head to the website constitutionstudy.com. All my articles and videos there. And hey, if you can support the work that we're doing here, I would greatly appreciate it. There's a donate button right on the homepage. You can donate to one of my projects or just to the Constitution Study in general. We use it to pay for all the licenses and fees and all the travel I do that's part of the Constitution Study, bringing this message to the rest of the country. And if you can help, I would greatly appreciate it. Also, again, maybe sign up for one of the mailing lists. I've got some things that I'm working on early in 2023, and the best way to find out sooner, well, is to be on the mailing list. So usually where I announce it first. Now, I'm looking at some other things to do. I'm considering a membership program for people that want even a deeper inside look, maybe early access to content. I'm still working out the details. So if you have any ideas, please let me know. While you're at it, if you find me on social media, I'm on most of them. I'm on Twitter and Gab and Getter and Parler, YouTube and Rumble, Gab TV. Find my content and share it. Follow me on those platforms, share the content. It helps other people find the Constitution Study so that other people can get access to this wonderful information. Again, I'm working on more outlets. I will keep you informed, but the best way to find out is through one of the mailing lists. Most of all, it's all about sharing this content. I have some great partners that are sharing many of these articles and videos. I'd like you to be one of them. The content I put on the Constitution Study, most of it's there. It's free for you to use. It's free for you to share. That's the idea. And also, please let people know that they can find these videos either on Rumble, YouTube, Gab TV, or right here. And hey, maybe next time, bring along a couple friends as we gather next time at the Constitution Study.